Welcome. I am Jeff Bellomo, and welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo, where we discuss all things estate planning and elder law, and, well, hey, anything else we want to talk about. Now, on today's episode of the Red Wagon Estate Planning and Elder Law Show, we are going to talk about the differences between special needs trusts and supplemental needs trusts. That will be the topic for today, because that is what you, the viewers, are asking for. I have received a lot of texts and emails requesting that we discuss this topic, so we are going to take a few minutes and talk a little bit about it and really try to understand the concepts and what it is that we are trying to do in the special needs arena. As just a normal disclaimer, as we always do on the podcast, please do not take what you hear from this show, or any other show for that matter, to constitute legal advice. If you are looking for legal advice pertaining to a specific fact pattern or situation, please call an attorney licensed in your state that you reside in who practices in the area of law that you are looking for advice in. Then, and only then, after meeting with the attorney, should you constitute that as legal advice and take action based upon that information. This podcast and any other podcast or show should be used for informational, educational, and entertainment purposes only. All right, that was a lot of fun. At Bellomo Associates, we educate so that what happened to my family does not happen to yours. We offer free educational workshops in the areas of pre-planning for the estate planning concepts, and we will talk about such things as financial powers of attorney, the medical powers of attorney and living wills, as well as last will and testaments, revocable trusts, asset protection trusts, tax trusts, pretty much anything pertaining to the pre-planning context. If you are looking to plan ahead, that would be the workshop that you would be looking for. If you or a loved one is going to need skilled level care in the next 6 months to a year, and skilled care we define as if you need significant assistance with activities of daily living. Activities of daily living are eating, bathing, dressing, toileting, transferring, walking. Then you may need skilled level care, and if you're going to need it in the next 6 months to a year, that would probably be our Crisis Medicaid Workshop, where you will learn about how to preserve assets, which Pennsylvania still allows. In our state, they are allowing 100% for a spouse and 50% for a single individual, widow, or widowed. If you are looking for guidance for your family about how to have someone age in place, what that journey is going to look like, how to keep the home safe, how to navigate doctor's appointments, how to navigate understanding prescriptions and understanding everything that goes with that and what pharmacists and doctors are trying to tell the family, whether it's time to go to assisted, whether it's time to go to a nursing facility, then you may be in need or want to listen to our life care planning workshop. We have 2 licensed social workers on our team who will be able to help navigate that process for you and make a lot less stressful for you and the family. We also offer special needs workshops, which we will be talking specifically about on this podcast, and also post-death administration workshops after the loss of a loved one, how to administer the estate, how to do it properly, how to make sure that you don't have any personal liability, and that all of the inheritance tax are paid and done properly, and distributions to beneficiaries are also done properly. If you need any of that information, please call the office at 717-845-5390 or check us out on the web at www.bellomoassociates.com. That is B as in boy, ELLOMO, associates spelled out with an S.com. All right, so into our topic for today. Full disclaimer, I have been doing special needs planning now for about 20 years, and I definitely like to fancy myself as a champion in the area of special needs and somebody who understands and who does special needs trust planning as well as anybody. One of my mentors in the York area was also another really, really good, well-respected special needs attorney. and he sold his practice to me in, I believe it was 2019, may have that year off by a year or so, but just also an incredible champion for individuals with disabilities, and certainly respect the heck out of him and everything that he accomplished. And with his retirement and with me taking over his practice, I was, quite proud that I was able to carry that torch and continue to advocate and fight for individuals with disabilities and educate primarily on the different types of trusts, which specifically in our workshops, what we talk about are the differences between the first-party special needs trust and the third-party special needs trusts. And then when we start talking about first-party special needs trust, which are specifically the trust where an individual with a disability who is receiving public benefits may lose those public benefits because of maybe it's an inheritance, maybe it's a personal injury settlement, maybe it's just that they're working and they're earning too much money and they're going over the $2,000 threshold. Whatever the reason is, they may or will lose their government benefits if they don't do something. So the government created what is called a first-party special needs trust, also known as a D4A trust, and all of that stuff comes out of, I believe it was Ober 93, that created all of that first-party trust sort of concepts and the ability to do all of that. Now, we talk in depth about that, and then over time, the government then, you saw them kind of create pooled trust, which are with charities. The main difference there is that rather than when the individual with a disability passing away and the money going to the state up to the amount of care that was provided, the money will stay in the pot for the other individuals with a similar disability in the charity. And then you also saw the kind of coming of ABLE accounts. ABLE was a federal thing that came down. States interpreted it, kind of put their thoughts on it. And Pennsylvania, frankly, has a really, really, really good PA ABLE website. They based the concept on the chassis of the 529 accounts. And I think that they did a very good job with the website, answering questions, but also with the program in setting it up, making it very easy. There is a contribution limit in a year that an individual can contribute, and it is currently $18,000 a year as this is being recorded. Now, that can be a hindrance, right? 18,000 or maybe it goes up next year to 19,000 is still not a significant amount of money. But those are great in situations where maybe a person is working and they're just making a little bit too much. They're going over the threshold rather than just buying frivolous stuff, or rather than paying to have a first-party special needs trust created, they can put the money into the ABLE account. In a situation where there's a significant amount from a personal injury settlement or from an inheritance, then you're probably not going to be able to use the ABLE account, at least not by itself. Maybe you're doing a first-party trust and an ABLE account and using both of them, which is allowed. But in any event, all of that is what we teach in the workshop. So it's a very comprehensive, all right, if you're needing a third-party trust, which is you're going to be creating this for a family member with a disability, versus a first-party trust, which is the individual with the disability has too much money. What can they do? What are their options? That is where we're distinguishing those two. In all of our pre-planning workshops, we do discuss trust after death for beneficiaries. We often call them separate share trusts. But in the context where we are talking about special needs trusts, we do discuss them, we do provide for them, we do have them included in our plans so that we can provide for individuals with disabilities in a third-party trust context and not have to worry about paying the state back. Because it was never the individual's money outright, the state does not have a right to get paid back. That is why they call it a third-party trust, meaning it was created with someone's money other than the individual with the disability. When we get into the context of the individual with a disability having too much, that is a first-party trust, meaning they're creating it themselves. So that's a great overview of what we teach in the workshops and how special needs planning ties into them. Now, I have been requesting on the show what topics you would like to hear. So the last couple shows that we have put out have been based upon demand or requests or just questions that people are asking that they just want to know. All right, so the question is, what is the difference between special needs trust and supplemental needs trust? Now, my gut reaction, I had an answer, I knew the answer, and I was excited to do the podcast. And then I decided to do just a little bit of digging, mostly just to make sure that everything I'm saying is factual and correct. Also to brush up, you haven't done specific research on something in, maybe 15 years. It's very possible that it changes. So I just took a few minutes to do some searches and kind of check things out. And lo and behold, I am more confused now than I was when I initially was asked the question. So here's what I mean by that. I think that what I have always said on these shows, on these podcasts, is that they are used interchangeably. Specifically, I have always used them interchangeably in the context of, look, there might be a very minor difference. However, for what we're discussing, we're going to use them interchangeably. The entire point of special needs trusts or supplemental needs trusts is that we want to be able to provide for an individual with a disability to have access to money without losing the government benefits, right? In Pennsylvania, we always talk about having to put language in the document that says it is intended to supplement, not supplant, the government benefits, right? So we're going to enhance the person's life. We're going to allow the trustee to pay to the individual with a disability basically anything other than shelter and utilities. And that's really in the context of somebody who is receiving SSI, Social Security income, where if they have, whether it be income coming in or whether they receive something such as payment towards shelter or utilities, SSI will deem it as income. And because it is deemed as income, the individual will lose some of their benefits in the subsequent month because they had income. Now, it's not really income, but they're deeming it as income. So other than that context of SSI, the trustee can really pay out for what the individual needs. And they can in the SSI context as well. We just have to be cognizant of the fact that it will cause a reduction in benefit in the future month. So that has always been sort of the conversation around that topic. And what we always discuss with clients is the difference between that third party and the first party trust and what all of that means. Now, as I was digging into this, I'm learning a lot more in regards to the history. All right, so initially, third-party trusts were what was out there. The third-party trusts are created by anyone other than the individual with a disability so that the beneficiary can receive the money from that person, but also continue to get their government benefits, right? No problem. So we know we have that set up. We know that that's the history. Well, when Over 93 came out, Over 93 said, all right, we have to create an animal so that if the individual with the disability has an inheritance, an injury settlement, they're working and they have too much money and they're going over the thresholds for government benefits, they need to be able to create something. So they created the D4A trust, the payback trusts, meaning that when that individual passes, the state gets paid back up to the amount of care that was provided. So at that time, attorneys, practitioners, wanted there to be a distinguishment between these types of trusts, right? The first party trust and the third party trust. So practitioners, attorneys were asking, can we please call first party trusts special needs trusts and third party trusts supplemental needs trusts? Some people started doing that. It took some legs and then sort of fizzled out. So essentially, there is no difference. Essentially, most practitioners, most people are using them interchangeable. That distinguishment never really took effect. It never really caught on. And for the most part, people don't generally distinguish between them. They kind of lump them together. Well, then as I did a little more research, an article that I found was talking about the title, Special Needs Trust, Supplemental Needs Trust. The title Special Needs Trust is more focused on the beneficiary, right? While the name Supplemental Needs Trust addresses the shortfall of the government benefits. Again, the thinking of supplemental being protection of the government benefits and not losing it. And then another one was talking about Special Needs Trust limits distributions to items other than shelter and utilities, while Supplemental Needs Trust does not limit any category of distribution as long as the beneficiary does not disqualify from the government benefits. So I was going through doing all of this research, trying to come up with a wonderful podcast and really sort of answer that question once and for all about what is the difference between the two trusts. And ultimately what I came to was it's the same thing. What I think is more important and the language that we need to be extremely clear about is if we're talking about a first-party trust or a third-party trust. At the end of the day, all special needs trusts, supplemental or special needs, are going to be providing benefits for an individual with a disability in a way that they can receive the money, but also continue to maintain their public benefits. So that's in both. But I think where we get a little lazy, and I think where people get themselves confused, is there is a very big difference between mom and dad or grandma and grandpa creating the trust, third-party trust, right? A third party, someone other than the individual with a disability, because there are no paybacks. There's no reason for the state to have any rights to getting paid when the individual passes. When the individual with a disability passes, the money then transfers on to whomever the original person who created it wanted it to go to, presumably another family member. Now, why I'm harping on this a little bit is because I can't tell you how many documents I read that are third-party trusts created by someone other than the individual, and they provide language for payback provisions. That is wrong. There is no reason to provide payback for an individual when the money was never theirs, when the money was created by someone other than them. So what I think we need to really focus on is using the proper terminology between first party and third party. And that's really where I think the distinguishing feature is between the different types of special needs or supplemental needs trust is in the context of, is it a first party or is it a third party? One last comment that I just want to make in regards to this specific when we're talking about, from my perspective, where I think ABLE accounts got created was because they were looking for a way to not have an individual, maybe who's working, receiving modest means, but because of the income that they're working, they're going over the threshold, and let's just call it a $2,000 threshold for the sake of this discussion. So they were having to go hire an attorney, do a first-party special needs trust to accumulate money in it, and then allow the trustee to buy something. We were getting tons of referrals from group homes creating these first-party trusts in that context. And I think what happened was the government wanted a way to give an individual with a disability the encouragement to work, right? Because if you're disqualifying them, if they're working, now you're discouraging the work. They want to encourage it, so let's have them work, and let's figure out a way for them to get benefits and not lose benefits, but also not have to rush out and buy stupid stuff every month just to stay under a threshold. And they created the ABLE accounts. They put the limit currently of $18,000 limit that you can contribute in a year on it, so that if it was a significant amount of money, then they would have to do the first party trust. If it's a smaller amount of money, then they would be able to do the ABLE accounts. So that was, in my opinion, why they were created, right? And they're very easy to set up. There's no cost to set them up. There's very great information on the website, as I mentioned earlier, and it allows the family to set these things up and then pay out of it for medical qualifying expenses, which arguably is a little bit of a broader term. But regardless, great tool, great setup. Now, as you look at the federal statute, it does say that the state may get paid back up to the amount of care that was provided if there is money left over in the account. At last talk that I had with the Pennsylvania ABLE office, in fact, it was at a joint event, and we were both presenting up, I believe it was in the Camp Hill area, if I recall. It was a few years ago. And I was showing the chart that said that, states may get paid back up to the amount of care that was provided. The individual from the ABLE office was very quick to say that, we are not going after those funds. We're allowing them to be passed on, to which I think that's wonderful. I just reminded people that because the federal statute says that they may, if the current administration's position is that they're not going to, that doesn't mean that that position won't change in the future with administration changes. And therefore, I was always hesitant to tell parents, grandparents, aunts, and uncles to place money into the ABLE account because there is a possibility of payback. So in my opinion, if I'm the aunt, the uncle, the parent, the grandparent, personally, I'm going to put that money into a third-party trust that has absolutely no payback provisions and never will have payback provisions. And now I don't have to worry about if the state changes the position, if there's money left over in the account, the state having the ability to get paid back up to the amount of care that was provided. So I like to bring that up. I have had some people that certainly disagreed with me and said that, that will never change and that was not the intent. I'm not here to argue. I'm just looking at exactly what it says. And my understanding of what it was created for was a substitute for a first-party trust, because they didn't want individuals to have to pay lawyers to create it so that they can maintain benefits. So if that's the case, then it would sort of make sense. And it also probably explains why they did say that the state may get paid back up to the amount of care that was provided. Also, if those accounts were ever to go to the estate of the individual, the estate, of course, does have to pay back up to the amount of care that was provided, because there will be a lien against the estate if benefits were provided during the lifetime. And it is a requirement, as we're doing estates for older individuals, to write a letter to the department asking if there were any liens, in which case we would have to make sure that that was paid as well. So personally, I say use them for what they were intended. If anyone other than the individual is creating it, I would not be using an ABLE account. If it were me, I would be putting that in a third-party trust, and that can be done in your will. That can be done in a standalone trust during lifetime. So it's very easy to do. Definitely no paybacks. I hope this was helpful. Ultimately, my personal feeling is that there is no difference between supplemental and special needs trust, that ultimately all supplemental and special needs trusts are intended to protect individuals with disabilities so that they can receive an inheritance from other individuals and still get government benefits. That is my feeling. That is how I've felt. And ultimately, that is the goal of those types of trusts. Please, when you're talking about special needs planning, be very clear about the differences between first party and third party special needs trusts, because the rules are very different, and that is dependent completely on who is creating the trust. If it is the individual with the disability themselves, that would be first party. If it is someone other than the individual with the disability, that would be third party. The third party trusts do not have payback. The first party trusts do, which is why they are called payback trusts. They get to pay back the state of Pennsylvania up to the amount of care that was provided, also known as D4A trust. That is just the statute that created it. All right. Well, I hope you enjoyed the Red Wagon Estate Planning and Elder Law show for today. I look forward to seeing you on the next episode of the Red Wagon Estate Planning and Elder Law show, hosted by me, yours truly, Jeffrey Bellomo. Until next time, we'll see you real soon.